At 2 p.m. today, the Supreme Court will continue hearing several petitions that challenge the constitutional validity of the Waqf Act. Just yesterday, a bench of Chief Justice Sanjeev Khanna, along with Justices Sanjay Kumar and K.V. Vishwanathan, were ready to issue a notice on these petitions and issue a brief order. However, both the centre and certain states asked for additional time to present their arguments before any temporary order could be issued. During the hearing, the court had raised three main concerns. Number one, user-declared waqf properties. There are questions about the earlier court decrees that declared certain properties as waqf-by-user, which might now become invalid. Number two, the composition of the Waqf Council. The court noted that non-Muslims form the majority of the Waqf Council. Number three, disputed waqf properties. There is a pending inquiry by the collector regarding a disputed waqf property and whether it should be excluded from being treated as waqf property. Now, after the proceedings, Chief Justice Sanjeev Khanna expressed his worry over the recent violence in Murshidabad linked to the amendments to the Waqf Act, calling the unrest disturbing. The Supreme Court even proposed that the properties already declared as waqf, including those under waqf-by-user, should not be denotified. However, the centre opposed this idea, requesting another hearing before any such decision could be finalized. Additionally, the court questioned the centre on whether Muslims would be permitted to participate in Hindu religious trusts. In total, there are 72 petitions challenging the act. These include petitions from the AIMIM, the All India Muslim Personal Law Board, the Jamiat Ulama-e-Hind, the DMK, the Congress, and others as well. Now we're crossing over to my colleague Harish to bring us more on this. Harish, explain the concerns that have been raised by the Supreme Court and what we're likely to see today as far as continuing the arguments as far as the 70 petitions are concerned.
Yes, that's right. In fact, we should say that 10 years after the Supreme Court had struck down the NJAC, now yet another act passed by the Parliament and given assent to by the President is under very, very close scrutiny of the Supreme Court bench. And as you rightly said, three clauses are under scanner of the Supreme Court. Number one, the clause pertaining to the removal of waqf-by-user clause. The Supreme Court questioned, how can you rewrite history? There are several waqfs, 100 to 200-year-old, from where will they get documents? And also, remember, found evidence in the merit in the argument of Kapil Sibal, who had appeared for one of the petitioners, that waqf is a facet of Islam, facet of personal law of Muslims, and it can't be disturbed. So it was as a result of that Supreme Court mulled to pass an order that till the pendency of this petition and the adjudication of this petition, any waqf, either by court or endorsed by the court, either by user or by deed, cannot be denotified. Number two, even if an inquiry by a collector is on regarding any disputes, it will continue to be a waqf. Number three, only all Muslims in the State Waqf Board or Central Waqf Council shall be Muslims except the ex-officio members. But the Supreme Court stopped short of passing the order after the Solicitor General Tushar Mehta, appearing for centre, said that he needed, since Supreme Court is passing order on merits, he needed more time to argue. And today, at 2 p.m., more opportunity will be given to all sides, including the Solicitor General for Centre, to place on record their arguments. And a very important interim order can be expected. Back to you.
All right, Harish, thank you so much for joining us and getting us more crucial details. We'll continue to track the developments here, especially considering that the hearing is set to continue in a short while from now.